Welcome, everybody, to CRE Fast 5 Secret Sauce, the show where we hear real-time insights from commercial real estate industry leaders. I'm Karly Iacono. Today, I am so pleased to be joined by Tim Duggan, shareholder at Stark & Stark. Tim, welcome to the show. Great to see you today.
Great, Karly. Thanks for having me. I'm looking forward to this.
It's going to be a wonderful conversation, but before we jump into the meat of today's episode, why don't you just take a moment and tell us a little bit about Stark & Stark and your role there?
Great, thank you. I'm a shareholder at the firm. We're about 100 lawyers outside the Princeton area and a full-service law firm. I practice primarily in our real estate group. I'm chair of Stark & Stark's Eminent Domain practice, as well as our banking and creditors' rights group. I do, although they're not the same, there's overlapping in certain areas. I primarily represent property owners in challenging the government's right to take private property. And if they do have the right, I will take that to a jury in order for the jury to decide the amount of just compensation to pay to the property owner. I'm a trial lawyer and really enjoy trying cases.
You really enjoy fighting the government. I love it.
It's great. David and Goliath, when you're David and you get the wins, it's very rewarding. Although it's an uphill battle, but
well, we definitely need people like you. So thank you for being passionate about your job. Let's back up for just a second and start really basic. Tell us what eminent domain is. What is the simple definition?
The simple definition is the right of the government to take private property. Most people, a little bit of trivia here, most people think the power arrives from the Fifth Amendment of the United States Constitution, but it goes back before the Constitution. Most sovereign governments have the power to take private property for public uses. The Fifth Amendment does put certain restrictions on it, including requiring the government to pay just compensation when they take private property for any type of public use or use where there's a public benefit.
And what does public use mean? Feels like it could be broad.
That's a great question, and that has been litigated for a long time and will be continued to be litigated. When eminent domain first started, back when our country was being formed, and they're going out west, there was a lot of property, and they could build railroads, roads, infrastructure that we needed. And as time came on, as we progressed, and people started moving into these areas, there wasn't a lot of property, so the government had to take private property to continue to build the infrastructure we need. Originally, it was for a public use, and that would be the public use in the property. As time has gone on, they've watered that down to a public benefit. And that's where I think the problem is, because it's not necessarily a use where the public's going to use it or the government's going to use it, but you have these situations where the end user's a private entity. And the question is there a public benefit as opposed to a public use? And a lot of people may be familiar from back in 2005, the Kelo decision from the Supreme Court, and I think it was called The Little Pink House, was a movie made out of it. This very nice woman wanted to fight an economic redevelopment project where her property and a bunch of others were going to be taken by the government and given to a private developer. She said, well, that's not a public use. You can't do that. And the Supreme Court ultimately decided they could and said, well, I know it's not a public use, and yes, it's going to end up in the hands of a private developer, but there's a public benefit here. It's going to create jobs. It's going to increase the tax revenue for the local, and the area is going to be nicer. Therefore, yeah, I get it's not a public use, but it's a public benefit, good enough, and they could take it. That gets litigated a lot, where property owners will say, whoa, that's just a land grant to give it to the mayor's buddy. And the government will say, no, there's all sorts of different benefits. So as time has gone on, the Supreme Court has brought in from the public use into this public benefit, and it's been a problem really the last 20 years.
Wow, I have so many follow-up questions. That's amazing, because my impression of eminent domain was exactly what you started with, right? Roads, bridges, something that we absolutely need in that specific area. But now if it's broadened to public benefit, I mean, schools, parks, hospitals, more affordable housing, but there's just so many ways that could be interpreted. It sounds like that feels very far-reaching, let's say. So a few follow-up questions then on this, my new impression of eminent domain. Can someone in the private sector apply for eminent domain? If, let's say, the adjacent property owner doesn't want to sell, can they appeal to some government group and say, we are building this massive apartment building? They would phrase it like that, of course, and we need this park, and the only place to put the park is XYZ house, right? So we think we need to take this by eminent domain. Or does it have to start with a government development that then translates to maybe private interest later?
Yeah, that's a great question because, in my opinion, that happens often where a developer will come to the municipality and say, "Hey, we got a great project, but we can't buy the property." What in New Jersey, what the government's allowed to do is have a planner look at the property and give a report of whether the area is in need of redevelopment. Going back many, many years ago, that was really equated to blight. It had to be a blight condition where you might be in an inner city and you have 2 or 3 blocks where 3/4 of the homes are vacant. You can't find the owners. They could go in and redevelop these areas, these neighborhoods in these cities, and that's a good use of the economic development. That's driven by the government. But when a private developer wants to do a project in the town, they can approach the municipality, encourage the municipality to take the first step, which is, can we designate it as an area in need of redevelopment? Once it's designated and they serve the proper notice, then they have the power of eminent domain. So if that's not challenged early on in the process, then the next step is to adopt a plan, which would allow the project that you're talking about. And then they appoint a redeveloper, which is going to be the person that wants to do the project. Then they come in, take the property, and give it over to the redeveloper. And we do a lot of challenges there because it really comes down to, what's the condition of the property? Do you meet the statutory requirements? Is there a blight aspect? Or is it purely a land grab to
Right.
benefit a private property owner? And that happens. And we've challenged those many times. They're hard cases, but we've won them.
Aside from housing and open air spaces, two things that most towns are in favor of in some regard, what other eminent domain cases have you seen that maybe were surprising, that qualified for public benefit?
Um, we had one that we recently resolved where because the property was already designated in the need of redevelopment when my client acquired it, my client entered into a lease for a cannabis user to come in and rent the property till they got their approvals. Once they got the approvals, they didn't want to buy it from us, so they went to the township and said, "Hey, it's in a redevelopment zone. Can you take it by eminent domain and give it to over us, who is the existing tenant?" And they
Wow,
did it. And then we fought it, and the case ended up getting dismissed. But that's one I think.
creative.
Um, I think it was an overreach. We were in court, and then
Mhm.
we ended up settling it where they're not going forward. They decided they're not going to try to take it. I really felt that under those circumstances, that was a pure land grab from a
Right.
private to a private with really no public benefit, because we had the property listed. So if it wasn't this person, it was going to be the next person. I mean, it
Right.
was listed. We took it off the market, and then at the end of the lease, they were supposed to buy it, but didn't like the price. But the government came forward and tried to take it. So we have situations like that that are very problematic. Another one is, we spent several years fighting a large natural gas pipeline coming through New Jersey,
Mm.
which is really an interesting infrastructure project. And then how they go about doing it and how it impacts the public is very disturbing.
Fascinating. This is so much broader than I realized. And probably most people don't even give eminent domain a second thought unless it immediately affects them unexpectedly, right? Or unless they're developers, right, who've dealt with large scale projects for some time. But individual property owners, I would assume this is something that never crosses their mind until all of a sudden they're in the middle of something way over their head, and they're trying to sort it out. So very interesting. Talk to me for a second, Tim, about how the process works. Let's take a simple case, right? You have property along a highway, and the government wants to come in and widen the highway, and it's going to affect your property, and they need to take 15 feet off of your existing property. How does that process work? what should you do if you're the property owner in that case? And just how do you start out?
Oh, great. So I like to, when I talk to my clients, I'll put it in two different buckets. One is before they actually do the taking of the property, oftentimes the Department of Transportation will come in and try to clean up the access and bring it up to code. For certain sites, like retail sites, access is crucial. So you may have along a highway frontage, basically no driveway, no curb, and it's a nice big area you can get in and out. When the government comes in and does an eminent domain project for road widening, they will now bring that up to code, which may require a single driveway or two smaller driveways. And that could really impact your users at a retail site. So the first, in order for the government to do that, they have to give the property owner notice. The property owner is entitled to have a hearing or a meeting before DOT, New Jersey Department of Transportation, to review the changes and try to negotiate something that's less harmful to the property owner. Usually we'll tell our clients, let's bring in a traffic engineer. Let's have the engineer explain to DOT how this is going to impact your property and your end users, as well as trying to come up with other ways that might be beneficial to you. It's very important because you get a notice, an opportunity for a hearing, and there's certain deadlines in there. So the property owner, once they hear about a project, they need to get a hold of a lawyer and find out, is that project going to change highway access? Because that happens first. Once the access changes are done, then they'll come in and take the property by eminent domain. The first step is they have to make an offer, enter into bona fide negotiations to try to buy your property. They'll usually send you a letter with an offer and a copy of an appraisal saying, we believe the compensation should be $50,000. And you're like, oh my God, this is terrible. This is going to kill my site. And you go back and forth and negotiate. After negotiations are done, they can file a complaint and take the property. And New Jersey is what's called a quick take state, which means they file a complaint. And usually within about 6 weeks, you have a hearing. There's one issue at that hearing. Does the government have the right to take the property? If the court says yes, during that time period, the government will pay the money into court, whatever the offer was, and file what's called the declaration of taking. They'll file that with the county clerk. Boom, they own the property. So within basically 6 weeks, if they deposit and file the declaration of taking, they will now own the project and can go forward and start construction. The second part of the case is how much they ultimately have to pay you. So they just deposit their offer, which is usually ridiculously low. And then you could have a jury trial on the amount that the government has to pay you. You'll have a commissioner's hearing, which is sort of like a non-binding arbitration. Each side will present their case and they'll come up with a number, but that's not a jury trial. That's just three people appointed by the court. Either side can reject that, whatever the number is. In most cases, we'll have a jury trial. And the jury will decide the amount of just compensation. So we'll have usually a panel of 8 jurors, 6 will vote. They'll listen to the testimony of the experts and come up with a number. So the jury verdict sheet is interesting because it's just a line with a number. The jury hears everything and comes up with a number.
So Tim, the 6 weeks that you mentioned, that's before the jury trial, right? It doesn't necessarily have to go to jury trial. Just kind of summarize those two timeframes for me again.
Sure. So when a complaint's filed, because New Jersey is a quick take state, which allows the government to quickly take the property to proceed with the project, especially when it's a public project and there's probably not going to be a big defense, you're just going to litigate over how much money they have to pay. So within approximately 6 weeks, there's a hearing on the right to take. During that time period, if the government wants to physically take the property and take possession, they can deposit the pre offer amount in the court. So let's assume they offer you $50,000 to take a 5-foot strip in front of your property. They can pay the $50,000 in the court. They can file what's called a declaration of taking, and then the court will decide the right to take. And once the court does that, and they deposit the money and file a declaration of taking, the government now owns the property and could proceed forward with the project. And that's step one. Step two is how much do they ultimately have to pay you? The 50,000 is just their offer. They throw it in the court. It's not evidential. It doesn't go before the jury. Then the property owner is permitted to go out, assemble their own proofs, usually an appraiser, sometimes an engineer, planner, depending on what the type of property it is. Then you have a commissioner's hearing, which is 3 people appointed by the court, and they just listen to both sides and come up with a number. But either side can reject that number. It's the goal there is to try to see if early in the case you can present your case and try to get a settlement. But if either side is unhappy, within 20 days, they file what's called the trial de novo, which just rejects the decision of the condemnation commissioners, and then you can have a trial. Usually the trials before a jury. 8 people will be a panel generally, 6 will vote, and they'll listen to both sides. Usually it's a battle of the appraisers, and then they'll come up with a number, and that's the amount that the government has to pay for the property.
So 6 weeks, within 6 weeks, the government can have rights to your property, and then the negotiation on what those rights are worth can go on for months, it sounds like, after.
Years. That's the problem. So
Years.
yeah. So if
Wow.
it's a, let's assume it's a total taking of your property, and they pay a small amount. We had one where they, offered us $1.3 million. We rejected it, and then 2.5, 3 years later, we ultimately settled for $4.5 million. We didn't have, we got the million out of court, but our 3.5 million was held up for 3 or 4 years when the stock market was going up, the real estate market was going
Wow.
up. We didn't have access to that money. All we get
Mhm.
is some interest from the court.
Right.
It just doesn't make
Probably
you
pretty
whole. We
low.
had all, it is, and
Right.
we're incurring costs. We have appraisers, we have engineers, we have lawyers. We're gearing up
Right.
for trial. So that initial take is a quick take, and then it's the slow train to get paid, and that is basically pretty unfair.
Very painful. I'm amazed the government can do anything in 6 weeks. That has to be the fastest thing in real estate, right? We'll wait 9 months, 12 months for approvals on a project, but yet within 6 weeks, they can have rights to your property. That's crazy to me. After that 6 week period, during the long negotiation of the compensation, can the government start on the project? So is it, or
Yes.
do they have all legal rights to do whatever they want with the property while you're still negotiating the cost benefit?
Yes. So as long as they deposit the
Wow.
money into court and file a declaration of taking, which is basically a 2-page document, you run down to the county, they're done, they can take it, and they can start with the project. And the goal
That's
there
incredible.
was not to hold up the government for standard projects of road widenings, things like that.
Right.
And they'll work with you. I mean, for example, if there's tenants and it's a total taking, they have to relocate the tenant. So if it's a total taking where they're taking the entire property, it's a little more complicated because they have to relocate the business and tenants. But if it's just a road widening, they can take the property and start right away, and you really have no say in the construction phase of it too. That's very problematic, and it's outside the scope of the negotiations, which is, if you're on a highway in your retail site, are they going to do it at night? Are they going to do it for the day? They'll generally try to keep half your driveway open, but when you have all the cones and the construction, and you're a fast food restaurant, I don't know who's going to slow down 60 miles an hour on a highway to take a turn in half a driveway. They're going to go to the next fast food place. So there's
Yeah,
a lot of
that's
harm that
tough.
does not get compensated. That's tough on the tenants.
Now, do you see total takings or partial takings more frequently? Is the most common expression of eminent domain the highway widening that we all think of, or is it pretty common to have total takings as well?
I see more partial takings. So right now we have a lot of infrastructure projects. For example, when they do a bridge repair, they will try to clean up the access around the bridge repair, and they'll put in sidewalks. So that'll be a partial taking of 5 or 10 feet. The gas pipeline was 116 miles. They were just trying to take easements to be able to put a 36-inch. It's a 3 foot pipe into people's
Significant.
property with high power gas. And in that particular case, I had a bunch of nonprofits, we had a bunch of preserve farms, and then a bunch of homeowners going through their backyard 80 feet from where their kid sleeps. And
Yeah.
what it is, it's a partial taking, and that's the right to put a pipe underground. And we fought that for a number of years, road widening, bridge projects. But we also have a fair amount of total taking in the area of that economic redevelopment. That's
Mm.
where we see, we have a number of them now, a number of total takings where they are using the economic redevelopment basis for eminent domain to take property to transfer from one private property owner to another to build out a project.
Got it. So if you are a property owner and you do not want to participate in the government's master plan, what steps can you take? Can you stop that 6-week quick claim taking process? What rights do you have as a property owner? You mentioned the gas line. I mean, that's a very poignant example. I can't think of anyone who would want a 3-foot wide gas line going through the residential backyard. That seems quite dangerous. So what rights do you have as a property owner, and what steps should you take if you get a letter like that?
So it really depends on the type of project. So if it's, for example, a road widening or they're taking a property for a school, it's going to be hard to challenge the public use because the public's going to
Right.
be using that property. You can challenge it if they don't enter into bona fide negotiation. So if they give you a take it or leave it and don't enter into bona fide negotiations, the court will dismiss the case. This past year, we had a case dismissed where New Jersey Transit, we did not believe, entered into good faith bona fide negotiations, and they filed the complaint anyway. We argued before the judge that they just didn't negotiate with us, and we were very offended by it, and the court agreed and dismissed the case. Now, they can come back around and try it a second time and do it the right way. So generally, the only way to stop a public project is to have a lawyer get involved early and look at the notices. Did they enter into bona fide negotiations? Basically, they cross their T and dot their I's. It's totally different if it's an economic redevelopment project where they are going to designate a property, an area in need of redevelopment, and then ultimately have the goal of taking your property and give it to a developer. Those are very, though there's a lot of challenges there, but you've got to get in, you got to get a lawyer and sometimes a planner involved very, very early because
Mm.
they'll plan some of these redevelopment projects early on. And there's a bunch of little deadlines that if you miss, you can't challenge. For example, there's something called a prerogative writ of how you challenge certain governmental actions. When they designate the property in need of redevelopment, if they properly notice it, you have 45 days to make that challenge, or you can't challenge it when they come to take your property. So those challenges you need very, very early to get involved and follow it. If you're not sure, you could use OPA requests to get information. That's Open Public Records Request Act to get some of the documents so you can jump on it early. And then finally, if it's a partial taking, a road widening, it's very important to make sure that you're in communication with the Department of Transportation or whoever's doing it, so you can sit down with them and talk about the access to the modification of the access. We've had it with restaurants, with retail sites, where we've been able to come in and have our engineers talk to their engineers, do the traffic engineering talk and dance, and see if we can try to minimize the damage, because sometimes the government doesn't know, okay, this is how the patrons come in and out. That's true, but what about my food deliveries? What about my
Right.
beer deliveries? Do I have small trucks? Do I have big trucks? Can they make that turn? And sometimes they may not be familiar with what your business is. So it's crucial to meet early, because once they go through the access process and you don't request a meeting or appeal, it's really hard to come back and challenge that down the road.
So many complexities to this. I imagine you get a lot of clients who are just kind of frazzled when they first call you. Maybe they've missed a deadline, maybe they're unsure what's happening. It really sounds like a challenging process.
It really is, and it's emotional because I suppose a warrantless search or a strip search would probably be the most invasive thing the government does, but the second most is taking your property. I mean,
Right.
we have a really tough case where they're putting New Jersey Transit's putting this monstrosity of a cabinet looking thing for safety equipment that's 14-foot high on an easement right on our client's driveway. They're putting it there. Now, it's
Uh,
a hard thing to challenge, and this is their retirement home. Every day they got to walk out and
oh
look at
my
this
gosh.
thing,
Right.
and we can't force them to move it somewhere else. We'd love to,
Right.
but now we've got to determine how much did the house drop because of this thing,
Right.
and a jury's going to have to decide it. But it's a very tough case, and it's very emotional because it's why me, why my property,
Right.
and and that's a we get there's a need for it, but it's very unfortunate for your property. And the same thing with the when the pipeline was coming through, you're like, well, why'd they pick this route? Why are they going through residential properties? Why can't they go along the highways? But they went before the federal regulatory agency, FERC, and got the approvals for this route. And now it's going through
Mm.
people's backyards. We had like 40 preserved farms under the Delaware River.
Oh my gosh. Wow.
And everybody from, gee, this is natural gas, stop greenhouses, to, boy, you're ruining the environment, or what's this going to do to the value of my house now that I got this big pipeline in my backyard. Very emotional cases. And it's at the end of the day, it's all about the money, but it's not about the money for them.
Of course. Very well said. Last question. Is there a specific type of property that you see this happen more often? Is it retail because it's along the highway? Is it industrial because there's more, I don't know, maybe development going on? What do you see most frequently?
I think if the most is really the two I see the most are, road widenings along the highways that
Mhm.
impacts retail the most. If you have an office and they tweak your access, it's probably not going to kill you. Now, what they can do is cut off your access and give you what they call reasonable alternative access, which is access to your property from another road. That is
Mm.
truly a harm, and you don't always get compensated for that. We do find a lot of these bridge and road projects, retail sites that
Right.
I right now I have some restaurants, car dealerships, and other properties. Then the second thing we see a lot of is the redevelopment takings. And a lot of those are in areas, some of them are in cities. You've seen a lot of it over the past, 10, 15 years up in Jersey City, the redevelopment laws. And some of these redevelopment laws and using the takings have been very successful, used the right ways, have been able to turn around some of our cities to foster a private public partnership to redevelop areas that just can't get it done with private people. They need some help,
Right.
and that help can come from the government. For retail sites, they changed the law a couple of years ago to help retail centers that are half vacant to be able to use the redevelopment law to redevelop those. So on one hand, you could say do nothing and let them sit. On the other hand, well, let's get creative with the redevelopment process, negotiate maybe some tax abatements with the property owner to get a project that really helps the municipality and everybody else around. Get rid of an eyesore, get your tax base in there. But it's got to be done the right way. It's got to be a true need for it, not, gee, I'd love that piece of property. Wink, wink, can you get it for me?
Exactly. And I think that's really the message, right? That this is not always a negative thing. Some of these projects are wonderful, and of course, we're pro development, being in commercial real estate, but it's got to be done fairly. And we want our property owners to not be taken advantage of, to be represented, and to really preserve their rights through what is quite a complicated process.
Yes, and it gets quite expensive
Right.
if you're challenging what the government's doing without a condemnation, you don't get your legal fees reimbursed. If you win a condemnation case and get it dismissed, then you could apply to the court for legal fees and recovery of your
Mm,
appraisal and engineering fees. So sometimes you'll have people with pretty good properties, but they have cash flow problems and they need to hire a lawyer. A lot of those on the valuation side, we will do on a contingency fee basis. So they don't have to pay us as we go along, because sometimes, quite frankly, they can't. And other times, if it's truly a very, very important property right that's being attacked, there are some very good nonprofits that'll have lawyers that are really, really good at briefing and fighting some of the more important property rights challenges throughout the country. Just you got to keep the government on their toes, or they will overreach. They will.
that is for sure. Tim, this was extremely eye-opening. Is there any final advice or thoughts you'd like to share with our listeners before we wrap up today?
Yeah, I just two things I'd like to say is, one is, no case is too small. You can find a lawyer. There's a number of very good eminent domain lawyers in Jersey. We had an impasse with a municipality in Burlington County. They're at 25,000. We're at 85,000. My client was this wonderful elderly woman, and we felt she was being pushed around. No way did they think I was going to go down there and try a case for 85,000 bucks, and we did, and the jury came back with our number. Those are important cases, those small ones, because the government has to be held in check. So if you do have a smaller case, call around and you'll find a lawyer that understands this that may take it. The second thing is there's a need for speed here. You really have to get involved early in the process so you don't lose your right to make certain challenges. In the redevelopment area, that's very early on in the process when they do that. The designation stage, you got to go in and attack it and file your appeals back then. On the road widenings, pay attention to the access. If you get something in the mail that's talking about modification of access, you really have to jump on it to make sure that you understand how it is. And third, don't assume a small taking is small damages. We had one where it was just 5 feet. Initially, our client didn't think it was that much, but moving the right-of-way line just 5 feet back would prohibit him from parking his cars out in front of his car dealership. So before the taking, he could put 30 cars out front, just 5 feet. He no longer could park the cars out front. So now you have a car dealership that you can't put your inventory out front. It's very important that you get the right professionals together to look at it, to really understand how does it impact my use today and how does it impact my use down the road. And you're in this field, Karly. I mean, a lot of these properties get reinvented as time changes and the market changes, and you get one bite at the apple. So you only get one chance to get just compensation, and you have to look at how does this impact me today and how does it impact me down the road? Because sometimes the impact down the road is devastating if you find out down the road, wow, this changed me. I'm now non-conforming, and oh my gosh, my setback is killed. So those are the things you have to analyze up front. So the third point is to get a good team, oftentimes traffic engineers, planner, and an appraiser, and then a lawyer to walk you through the process.
That's all. That's it. It makes it so simple. No, I'm kidding. Incredibly complex. This was very, very insightful, and you are a fantastic resource. So thank you so much for sharing all the ins and the outs and what steps owners need to take if they think they might be facing eminent domain, because it is no small thing. Tim, we very much appreciate your time. Thank you so much for being a guest on the show today.
Great. Thanks for having me. And I'm looking forward to seeing this as I watch all your other podcasts. They're great.
Thank you.
Really happy to be on this.
Thank you so much. And to everyone listening, that was CRE Fast 5 Secret Sauce. Thanks for tuning in, and we will see you again very soon. Have a great day, everyone.